We have attorney William Messervy joining us right now from our friends over at Timberlake and League. And of course, we appreciate you being with us, William, as always.
Glad to be here.
So while we wait for our first call, I think a lot of folks, when they get injured, they immediately think about calling the lawyer to file a claim. But how do sometimes any kind of pre-existing injuries affect possibly the outcome of that claim?
Yeah, it's a great question. So, a lot of people, unless you're age 18 at the time of your injury, are going to have some pre-existing conditions, and that matters if you injure the same part of your body where you've had injuries previously, prior to the wreck or the fall or whatever caused your injury. And, it's not going to be evaluated in the same form or fashion as if you've never had an injury to that body part before. But the good news is you are entitled to recover for what is an aggravation of a pre-existing condition or an exacerbation of a pre-existing condition. So in other words, if your pain level from your neck was at a 1 and now it's at a 4, presumably you would try to make a recovery for the difference between where your neck is now and where it was prior to the injury. But it is going to have an effect on the value of your claim and something that you would need to take into consideration. And it's pretty commonplace. It's something that, someone in their 40s, 50s, or 60s is likely to have some pre-existing condition, and it can be impacted. The other thing is you can have what are called degenerative changes throughout your body. That could be, anything from a disc herniation to degenerative disc disease, osteophyte complex, something along those lines. But you can be asymptomatic prior to the wreck and then made symptomatic by the wreck or the fall or the injury. And so you can make a recovery in those situations as well.
I want to remind folks once again, the number to call to get your legal question answered is 256-536-0077. I do believe, William, that we have Lindell on the phone right now. Are you there?
Yes, sir.
Go ahead with your question.
Okay. I live in assisted living, and there was water coming in my apartment. They wouldn't do anything about it. The results was mold growing on the ceiling, and it got on my mattress, and they will not replace my mattress.
Yeah, so this is, believe it or not, really a contracts question, right? And it would come down to what your agreement with them is. What is the contract that allows you to reside there for the amount that you're paying every month? And most folks will know that as a lease agreement. And it's not going to be very different in this situation, but it boils down to, what is it that they're supposed to do under these types of circumstances? The other question becomes, is it still sanitary, or is it at this point non-sanitary? Because there is a medical component to your residency there as well. So it's something to be looked into. I'd contact a lawyer if you're unable to resolve that matter on your own with them, and see what can be done to resolve that situation. It could be as easy as writing a letter.
And again, 256-536-0077 is the number to call if you've got a legal question you'd like answered. And I believe we have Shell on the line right now. Are you there?
Hi. Yes, I am.
Go ahead, Cheryl.
Me and my husband, we're both remarried. We've been together for 20 years, and he went and made a will without me. Okay, when we passed, everything would go to his daughter and not to my son. So if I went and I had a will made and my name is on the house, is that going to be any different for my son to get half of what we have together?
Yeah, so I would encourage you to meet with an estate or elder law lawyer with regards to that. But essentially, marital property is marital property, and one spouse can't give that away without the consent of the other spouse. And in that scenario, it would matter who passed away first and who passed away second. So to best protect yourself and your heirs, I would meet with an estate lawyer separately and follow their advice as to what to do to protect yourself in that scenario. But he's not going to be able to give away marital property that you're entitled to.
May I ask a question related to Cheryl's
Absolutely.
question? So, if somebody does whose name is on the deed and whose name is on the mortgage ever come into play, and how that's rationed out?
That can make a difference, but for a couple that has been married for 20 years, it's not going to make a significant difference whose name's on the deed. It's still going to be considered marital property under that fact pattern.